My mom stood up in open court, pointed directly at my wife, and screamed, in front of a sitting judge, "She is a total disgrace, and she doesn't deserve a single penny." The entire courtroom went completely silent. And then the judge leaned forward, adjusted his glasses, and said something that ended her completely. "I'm 34, structural engineer, married 4 years to a woman who, according to my mother, committed the unforgivable crime of being kind to a dying man. We had a decent apartment, a rescue dog, good jobs, a genuinely solid life, until my dad got sick and everything I thought I understood about my family quietly caught fire. My dad was diagnosed with stage 3 lung cancer in January of the year before he died. He fought hard. Treatments, hospital stays, weight loss, all of it. Through every single appointment, every rough week, my wife showed up. She drove him to chemo when I had to be at a job site. She cooked for him when he couldn't stomach much. She sat with him on bad nights, watching old westerns until he fell asleep in his recliner. She did it without being asked and without keeping score. My mom had been divorced from my dad for 11 years by the time his diagnosis came. They had maintained a civil relationship, holiday texts, occasional calls, nothing more. Then he got sick, and something switched on in her that I didn't recognize at first. She started coming around. It looked like concern initially. She'd bring food, ask how he was doing, stay for an hour. But the comments started. Every visit had a few. About the house. My dad's house. The one he'd kept after the divorce. The one I grew up in. "I helped choose that kitchen," she'd say. "Your father wouldn't have that back fence if I hadn't pushed for it years ago." After one of those visits, my wife pulled me aside. "Your mom is circling something," she said. "She's just processing. Dad's sick." "It's emotional," I said. "She's not grieving. She's calculating," my wife said. "You're reading into it." She looked at me for a second and didn't push it. I wish she had. My dad passed in October. He was 61. The grief was real, and it blurred the weeks around it. Then the will was read, and everything came into sharp focus. My dad had updated his will 14 months before he died, shortly after his diagnosis. He left liquid assets split between me and my younger brother. He left his house, the family home, jointly to me and my wife. He left my mother a specific cash sum, which was genuinely generous given 11 years of legal separation, but it was not the house. It was not everything. And for my mother, apparently, everything was the only acceptable amount. 6 weeks after probate opened, she filed a formal contest. Her claim: my wife had exercised undue influence over my father during his illness, manipulating a vulnerable, medically compromised man into altering his will in her favor. My dad, a man who had run his own contracting business for 30 years without once letting someone else make a call for him, was suddenly, in legal documents, a confused victim. I called her the day I found out. "Mom, you're claiming my wife manipulated a dying man. You're saying Dad couldn't think straight." "I'm saying someone took advantage of a difficult situation," she said. "I'm not pointing fingers. You filed a legal document. That's literally pointing fingers in writing." "I have rights," she said. And then, sweetheart. That word landed like a door closing. She wasn't grieving anymore. She was operating. My attorney, a probate specialist I found through a colleague, explained the legal landscape. An undue influence claim requires proving 3 things: that the alleged influencer had a confidential relationship with a testator, that the testator was susceptible to influence, and that the resulting will was a product of that influence rather than his own free judgment. "She'll need more than feelings," he told me during our first meeting. "But feelings dressed in legalese can go a long way if we're not ready." "What do we need to be ready?" I asked. "Proof that your father was thinking clearly and acting freely," he said. "Proof the timeline doesn't support her story." I nodded slowly. Then I told him about the video. He put down his pen. My mother began her campaign almost immediately. She worked the phones, extended family, cousins I hadn't spoken to in years, my dad's older brother, a neighbor from the street they'd lived on when they were still married. I started getting texts from people I barely knew, saying things like, "Your mom seems really broken up. Have you considered her perspective?" One cousin told me she'd been asked to sign a written declaration stating she had observed my wife behaving in a controlling manner around my father. The cousin had met my wife exactly twice, once at a graduation and once at a birthday dinner. I didn't call my mother screaming. I didn't send angry texts. I opened a document on my laptop and started logging everything. Every voicemail, every secondhand account, every name she'd contacted. My wife thought I was spiraling. "You're obsessing," she said one evening. "I'm building," I told her. "There's a difference." "What exactly are you building?" I turned the laptop toward her and said, "A case." She looked at the document, 3 pages of names, dates, and notes, and was quiet for a moment. Then she said, "Your dad would have done exactly this." She wasn't wrong. And as it turned out, my dad had already done his part long before I started mine. About 3 weeks after my dad executed his updated will, he called me and asked me to come to the house alone. No explanation, just come over. When I arrived, he was sitting at the kitchen table with his laptop open and a small tripod set up in the corner, camera facing his chair. He was thin from the treatments. His eyes were sharp. "Sit down," he said. "I want to show you something I made." He turned the laptop toward me and hit play. It was him. Filmed on a Thursday afternoon, about 20 minutes long. He was looking directly into the camera, speaking slowly and clearly. He walked through every decision in his will. He explained the house, why he wanted me and my wife to have it, what it meant that she had shown up for him the way she did. He talked about my brother. He talked about the cash distribution. And then he talked about my mother. He wasn't cruel. He was precise. He said that in the months following his diagnosis, she had made it clear, through calls, through visits, through what he described as persistent suggestion, that she expected to be included in his estate as if the 11 years since their divorce hadn't happened. He said he loved her in the way you love someone you spent 2 decades building a life with. But he was not going to rewrite legal reality, because his illness had made her feel the window was open. He looked into the camera and said, "I want it on record that every decision in this will is mine alone. No one influenced me. No one pressured me into anything. I am a 61-year-old man who has made his own choices his entire life, and this is one more." Then he told me to store it somewhere safe. "I hope you never need it," he said, "but I have a feeling you might." I made copies that night. 2 external hard drives and a cloud backup. When I showed my attorney, he sat back in his chair and stared at the screen for a long moment after it ended. "This is a recorded testamentary capacity statement," he said. "Filmed weeks after the will's execution. Clear cognition, no distress, no indication of external influence. This is exactly what courts want to see when someone challenges mental capacity or free will." "She doesn't know it exists," I said. "Perfect," he said. "We don't tell her until the hearing." Meanwhile, my mother kept escalating. She hired a private investigator. I found out when my wife mentioned the same gray sedan parked outside our apartment building 3 days running. I told my attorney. He sent a cease and desist. The PI disappeared, but the paper trail stayed. I added it to the file. Then came the coffee meeting. She called and asked to talk, just the 2 of us, no attorneys. I agreed. I told my attorney first, who told me to go listen and record. Ohio is a one-party consent state. I hit record before I sat down. She spent 20 minutes talking about sacrifice, about the years she gave, about how my wife had come into the family and positioned herself, about how the house should stay in the bloodline. Then she slid a paper across the table. "What is this?" I asked. "A proposal. You sign the house over to me." I dropped the contest. Everyone moves forward and heals. "And my wife? Where does she factor in?" "She can remain in the house," she said with a small shrug. "Rent would be negotiable." I picked up the paper, folded it, and put it in my jacket pocket. "I'll think about it," I said. I handed it to my attorney the next morning. He held it up like it was a museum piece. "She just offered a settlement that constitutes a written admission she expects to lose," he said. "This is almost impressively bad legal instinct." I told him that was the most comforting thing anyone had said to me in months. He said he'd add it to the file. Probate lawyers apparently have a very specific kind of dark humor, It's the only way to survive the job. My brother called me around this time. He wasn't named in the contest, had no legal stake, but he was watching everything quietly. I don't think she actually expects to win, he said. What do you think she expects? I asked. To make it painful enough that you give in. That's not going to happen. I know, he said. I just wanted you to know I know that too. That mattered more than I let on. The hearing was scheduled for a Tuesday in late June. Discovery had run through spring. Both sides exchanged documents, submitted evidence, deposed witnesses. My mother had gathered 11 declarations from family and acquaintances, most of them describing observations of my wife that ranged from vague to implausible. Several used nearly identical phrasing, which my attorney flagged immediately as coordinated. The night before the hearing, I slept 3 hours. My wife made coffee before 5 in the morning. We sat across from each other in the kitchen without saying much for a while. Then she said, "Whatever happens today, we handled this the right way." "I know," I said. "I need you to mean that, not just say it." I looked at her. This woman my father had trusted enough to protect on camera from a hospital recliner. I said, "I mean it." We arrived at the courthouse at 8:30. My mother arrived at 9, in a blazer I'd never seen before, with her attorney, a man I recognized from a billboard near the highway. She didn't look at me, didn't look at my wife. She walked in like she was arriving to collect something that was already hers. The judge took the bench at 10. Her attorney opened, practiced, and polished, I'll give him that. Susceptible testator, confidential caregiving relationship, suspicious timing of the will modification. He painted a picture of a sick man surrounded by an opportunist. I kept my face neutral. Then my attorney stood. "Your Honor," he said, "before we proceed, the respondent would like to submit a piece of evidence not yet entered into the record." The video began to play on the courtroom monitor. My dad's face filled the screen. My mother's attorney stopped mid-reach for his legal pad. My mother went completely still for the first time in 8 months. My dad spoke for 19 minutes and 43 seconds. He was measured, specific, and fully himself. He walked through every decision in the will, explained the house, described his relationship with my wife, and addressed the pressure he had received from his ex-wife following his diagnosis. He named it, he described it, and he stated, without any ambiguity, that it had not changed his decisions, only confirmed them. The courtroom was quiet except for his voice. When it ended, my attorney spoke into that silence. "Your Honor, this recording was made 3 weeks after the will was executed, in the presence of a notary who has submitted a sworn affidavit confirming the date, time, and the testator's apparent mental and cognitive state. We have also entered medical records from his oncologist confirming that on the date of recording, my client showed no cognitive impairment. The petitioner's undue influence claim requires establishing susceptibility. This recording, combined with the medical record and the notary affidavit, establishes the opposite. The testator was not susceptible. He was clear, deliberate, and completely in command of his own judgment." My mother's attorney leaned over and whispered something to her. She didn't look at him. He rose and asked the judge for a brief recess to review the newly entered evidence. The judge said no, and then my mother stood up, without being recognized, without a signal from her attorney, who looked, for a moment, like a man watching a car roll slowly into a ditch. She pointed across the room at my wife. "She is a total disgrace," she said. Her voice cracked once, then went loud and steady. "She does not deserve a single penny of what my husband built. She came into this family with nothing. She attached herself to a sick and vulnerable man, and now she is sitting here acting like she earned something. She is a disgrace to this family." Nobody moved. The room held its breath. The judge let her finish. He gave the silence a moment to settle. Then he leaned forward, looked at her steadily, and said, clearly and without any theater in his voice, "Ma'am, your late husband disagreed with that assessment, and he made sure he said so on camera." My mother sat down. Her attorney put a hand on her arm and stared at the table. The judge turned back to the room and continued, "I have reviewed the submitted video testimony. I have reviewed the will, the notarized execution records, and the affidavit from the attending physician confirming cognitive capacity at the relevant time. I have also reviewed the petitioner's submitted declarations from extended family and acquaintances. Several of those declarations employ near-identical language from individuals who, by their own deposition testimony, had minimal contact with the deceased in the final year of his life. That pattern is notable and has been considered. He paused. The petition to contest this will on the basis of undue influence is denied. The will stands as executed. 8 months. 11 recruited witnesses. A private investigator. A recorded coffee shop pitch to trade the house for peace. And it was over in under a minute. But I wasn't finished. After the ruling, my attorney filed a motion for attorney's fees. Under Ohio law, a court can order a losing contestant to pay the respondent's legal costs if the contest was brought without reasonable cause or in bad faith. My attorney argued bad faith, and we had the evidence to back every word of it. The coffee shop recording, the PI documentation, the coordinated witness declarations, the cash for house proposal she'd slid across a table thinking I'd fold. 6 weeks later, the judge ruled in our favor on the fee motion. My mother was ordered to pay our full legal costs. 14 months of litigation, expert witnesses, attorney fees, everything. The number was not small. She could have appealed. Her attorney apparently told her that. She did not appeal. She called me the night that ruling came through. I let it go to voicemail. Her message was quiet. She said she hoped we could find our way back to each other eventually. That she'd done what she believed was right. That she wanted me to understand she had loved my father. I sat on the back steps and listened to it twice. My wife came outside and sat next to me. She really believed she was going to get the house, my wife said. She believed the video didn't exist, I said. My wife was quiet for a moment. Then, your dad knew her well enough to prepare for this. He did. He had sat in that kitchen, sick and tired, and carrying more than I understood at the time, and he had set up a tripod and made sure the record was clear. He didn't do it dramatically. He just did it the way he'd always done everything, quietly, practically, and ahead of schedule, which is, I've come to understand, the highest form of love he knew how to show. The house is ours now. Legally, cleanly, with no cloud on the title. We moved in about 2 months after the fee ruling. My wife repainted the kitchen, the one my mother used to reference like it was historical property, and picked a color that somehow matched my dad's whole personality without either of us planning it. The first time my brother saw it, he said, "Dad would have called that color something unprintable." "That's exactly why she picked it," I said. "He would have loved it," my brother said. "He would have." My brother came out to the house a few weeks after we'd settled in. We sat on the back porch, and he asked if I was going to reach out to our mom. "When I'm ready," I said. "On my terms." "Fair," he said. He didn't push it. He'd watched the whole thing unfold and reached his own conclusions at his own pace. We were still solid, him and me. That meant something. The hardest thing to reckon with, looking back, wasn't the legal process or the money or even the grief stacked on top of more grief. The hardest thing was the moment I understood what my mother had actually been trying to do. She wasn't really contesting a will. She was contesting a verdict. My dad had made his final choices clearly and deliberately on camera in front of a notary, and those choices had included my wife and excluded any revision of the past. My mother couldn't bear that. Not because of the house. Because of what the house represented. His affirmation of a woman she had decided to resent, made permanent. That's a painful thing to be on the losing end of. I can hold space for that without endorsing what she did with it. But there's a version of this story where the video doesn't exist, where she buries us in legal costs, where the family declarations carry enough weight, where we fold on the house just to make it stop. She calculated on exactly that version. She bet that cost and exhaustion would do what legal merit couldn't. My dad had accounted for that too. The fee ruling was the piece that felt complete to me, not just because it hurt her financially, though it did, but because of what it meant structurally. She had used a legal process as a pressure tool, betting the cost of resistance would be greater than the value of fighting. When the court turned that exact cost back onto her, it wasn't just a ruling. It was the system seeing what she'd done and refusing to let it stand unchallenged. That's the thing about entitled people running dirty plays. They almost always assume the other side won't have the patience or the documentation to outlast them. My mother had known me my whole life and still miscalculated that completely. My wife and I don't talk about it much day to day anymore. The dog has the full yard now and has apparently decided the flower bed is his personal project. My wife is planning a garden for spring. I've been doing small repairs around the house, learning things my dad knew that I'm only now picking up, and every wall I open and every shelf I reinforce is a record of his choices. The way he built this place, the care he put into it. He did everything with intention, including the video. I think about that act a lot. The specificity of it. The fact that he saw clearly enough, even through his illness, even through everything, to understand that documentation was protection. That a tripod and a camera and a notary could do more for the people he loved than any amount of hoping things would go smoothly after he was gone. My wife said something recently that stuck with me. We were putting shelves up in the spare room, and she said, "We should get a tripod." I looked at her. "Just to have one around," she said, completely straight-faced. I told her my dad would have found that extremely funny. She said that was the point. My mother hasn't called since that voicemail. Maybe she will eventually. Maybe she won't. I'm not holding a door open or nailing it shut. What I know is that the house is ours. The will is probated. The fees are paid. And somewhere saved in a cloud backup and on 2 separate hard drives, my dad is still talking, clear-eyed, unhurried, and completely in his right mind, making sure everything turned out exactly the way he meant it to. If you think you'd go to court for what's yours and actually win, hit subscribe, because next week's story involves someone who thought a handshake deal was legally binding, and wow, were they wrong.